But let's, of course, start with this big story that's come in from the United States of America, where the American Supreme Court is hearing a case that will have some defining consequences. Now, arguments are taking place in the top court on race-conscious map-making, and also the outcome threatens to gut certain key provisions on the Voting Rights Act. Now, affirmative action or race-based discrimination. So far, the states are allowed to have minority-dominated congressional districts, but the Supreme Court could put an end to this practice. Now, the case stems from a legal battle over Louisiana's congressional map. The conservative litigators have argued against race-based map-making. They say that the Democrats are getting an unfair advantage due to this. Now, the issue has put the focus on Voting Rights Act, the civil rights era law that prohibits electoral maps that dilute voting power of the minority groups. Now, conservatives have said that the much-cited Voting Rights Act is being misinterpreted, and race-based gerrymandering of congressional maps is against the Constitution. Now, minority groups, particularly the African-American voters, fear the dilution of their voting rights, and the current precedent ensures representation. If race goes out of consideration while congressional map-making, minority groups might lose that minimum guaranteed representation. The Supreme Court bench is dominated by conservative jurists, and on the first day of the argument, a majority of the judges hinted at gutting Section 2 of the Voting Rights Act.
The issue, as you know, is that this court's cases in a variety of contexts have said that race-based remedies are permissible for a period of time, sometimes for a long period of time, decades in some cases, but that they should not be indefinite and should have an endpoint.
The bottom line is just get rid of Section 2, because the test you're providing doesn't do anything for the effects test that Congress identified.
Now, the 9-judge bench also has some liberal voices. 3 liberal justices of the bench gave a pushback against the conservative argument and strongly defended Section 2 of the Voting Rights Act throughout. 2.5-hour-long argument.
The race-based redistricting that you're now objecting to is redistricting designed to remedy a specific, identified, proved violation of law. More, a specific, identified, proved racial discrimination by the state. That's the way in which the race-based districting is coming in. It's coming in as a remedy for specific, proved discrimination on the state's part.
All right, now to give us more details on this, we're joined on this broadcast by our correspondent Susan Tehrani, who's joining us live from New York. So, Susan, tell us more about what this case is and the ramifications it's expected to have before the midterm elections next year.
Yeah, it's so important for the midterms, Mohammed, as you noted, because this could, depending which way the vote goes, and the Supreme Court is expected to ultimately rule on this in June of 2026. So whichever way that this goes, ultimately it will be, which party gets more seats in that district. As you mentioned, it all started in Louisiana with 2 districts. They argue that they have a 2/3 majority of a black population, and that's why their districts should be the way that they are. However, some came out and sued and said that gerrymandering essentially on race is not prohibited. So now the justices have this case in front of them to determine not only regarding the Voting Rights Act that protects minorities, but also the interpretation of that clause in the Voting Rights Act on whether or not you could ultimately redistrict based on race. So that's the fight, that's what's at the heart of the fight, so to say, as we speak.
Interesting. We'll have to see as to how this fight unfolds. Thank you very much indeed, Susan Tehrani, for joining us with those updates there.